Welcome to Leveraging Inspiration, the Inspired Patent Podcast. Apple bet on a trademark and lost, but then went another round and won. Learn why the best defense in trademarks is a strong offense. I'm Wayne Carroll, your host, here to share valuable insights, stories, and strategies for success in intellectual property. Let's dive into the game of IP and learn how to win. This podcast is not legal advice, but is strictly educational and informational. Listening to this podcast or reading show notes does not establish an attorney-client relationship. In this episode, we're going to talk about Apple's struggle for the trademark Live Photo and why the best defense is a good offense. We're going to, in 13 minutes here, dive through this case and learn all kinds of things about what can happen in a trademark filing. In 2015, Apple launched a new feature called Live Photos, where a 3-second video clip is recorded along with a photo. 1.5 seconds before, 1.5 seconds after, plus you've got a photo, and it's not as big as a normal video clip. In January of 2016, they filed a trademark in the United States Trademark Office. They were initially rejected. Hewlett-Packard had a trademark called HP Live Photo, and Apple was applying for Live Photo. And the Trademark Office rejected it, saying that it will be confused. The public will be confused, thinking that there's an association here. It doesn't lend itself to having two companies using HP Live Photo and Apple using Live Photos. So the other rejection they had was that it was merely descriptive, that Live Photos merely described what it is they were offering. And in response, Apple got a consent from Hewlett-Packard, but it was only signed by Hewlett-Packard, and they presented arguments as to why it should not be merely descriptive. The arguments generally are that even though it may look descriptive, their use of it over years and extensive advertising has educated the public that this is not anymore just viewed as a descriptive term, but the public has actually now recognized this as a brand of a specific company. So those are the arguments that Apple made, and they were rejected again, but this time they dropped, they said, you've overcome our rejection on merely descriptive. Merely descriptive means only descriptive and nothing else. If it's descriptive with that secondary meaning, that acquired trademark meaning, then it's no longer merely descriptive, it's descriptive plus. So they this time they obtained another consent from Hewlett-Packard that was signed by Apple and Hewlett-Packard to make sure they met the requirements for that consent agreement. And at the same time, they appealed it to the Trademark Trial and Appeal Board. But when the examiner saw that appeal and the consent by Hewlett-Packard, the trademark examiner said, oh, you're good to go. Everything's good to go. So the next step in a trademark application is that the application gets published and there's an opposition period. So the publication happened in September 2017. There's a 30-day opposition notice period. So a company or an individual, Gang Cao, filed a opposition to Apple's trademark for Live Photo. And this process, the actual complaint and everything started in October of 2017. This is very similar to litigation. A complaint is filed with alleging why they would be harmed and why they should win. Then Apple files an answer. They exchange some documents. Once one side files a motion for a summary judgment, it goes back and forth. That gets denied. Lots of discovery, depositions, gathering documents, lots of money spent. So between October 2017 and June 2021, this case was before the Trademark Trial and Appeal Board, going back and forth, exchanging documents and some motions here and there. The Trademark Trial and Appeal Board said that Gang Cao, I'm not sure if I'm saying it right, it's CAO. I apologize to those people who know I'm saying it wrong. The Trademark Trial and Appeal Board, they said live photo is generic, therefore it cannot be registered as a trademark. Well, Apple wasn't satisfied with that result, so they appealed to the federal district court. And in this instance, Gang Cao did not respond to the appeal. Rather, they just didn't show. And so there was when that happens, the side that brings the lawsuit or the appeal in this case and wants the judgment in their favor has to prove that they've given sufficient notice. So they went through that process. But even though their opponent, Gang Cao, did not appear, they still had to prove to the federal circuit why the federal circuit should overturn the Trademark Trial and Appeal Board. They were able to convince them. So then in February of 2022, the federal circuit or the federal appeals court agreed that Apple should get the trademark for live photo, that it was not generic, it was descriptive, and they agreed that it was descriptive plus. When it's descriptive alone, you can register it, but it goes on the supplemental register. It does not get on the principal register. And the difference between these two is that the supplemental register does not give you exclusive rights. It's similar to the rights you get just by putting TM next to your trademark, because when you go to court, you still have to prove that you've established rights that should be enforced as exclusive. You can put Circle R next to a supplemental register trademark, but you don't have exclusive rights as a default in court. So it's much weaker rights. Usually the supplemental register is used when you can't get around the ruling that it's a descriptive trademark and you haven't established enough evidence to prove that you have merely descriptive plus. So over time, while it's registered on the supplemental register, you can advertise and keep records of how you are using that trademark in the marketplace to educate the public that this is not just a descriptive term, but actually a trademark that is associated with your company. And so that's the process that Apple didn't want to go through. They had enough advertising. They had major media launches. They have the huge Apple marketing machine behind them. And so they had plenty of proof that people know about live photo and they should associate it with us. Plus they got Hewlett-Packard to agree that their HP live photo was for something completely different and that people weren't going to be confused. And so that's not a problem. And so they finally got their way, and they finally in 2022 got a registered trademark. And now Apple has that registered trademark. From 2016 to 2022 was the time period it took to go through this whole process. This is kind of your worst case scenario when applying for a trademark. And if you're a company as big as Apple, then you can fight that battle. For a lot of small and medium-sized businesses, they're going to have to assess. And this is what we help clients with, is at each stage, when the patent office rejects us, or the trademark office in this case, if we get a rejection from the trademark office, we work through strategies, and we may approach a company. Now, Apple had the clout to talk with Hewlett-Packard. If it's a company that you have that's on a similar standing and you're willing to work with them, I have worked with clients who have done the consent agreement with somebody in their same industry who doesn't want to ruffle feathers and doesn't think there's a problem. It's not a quid pro quo, but if you play nice in your industry, it often comes back in good ways for you. If you don't play nice, it can come back in bad ways. So surprisingly enough, people do sometimes play nice when they don't have to. And Hewlett-Packard did that in this case. And I've seen where it's worked for clients as well. One of the things that you'll need to assess is if a big company like Apple were to file an opposition against your trademark as a small or medium-sized company, you want to assess, is there a way to play nice with Apple instead of trying to fight them? And as you can see in this case, Apple didn't just say, once the Trademark Trial and Appeal Board said, that's a generic mark, you don't get it. They said, well, we're going to keep going. And their opponent probably ran out of money and said, I can't keep playing this game. This is expensive, because years of litigation is a lot of money. I don't know how much it was, but I would not be surprised if their opponent's legal bills were well over $100,000. So in that case, we work with clients to assess, what is the risk? How can we play nice? Oftentimes, large companies will agree that you can register that trademark as long as it's clear that you aren't in their space. So this is the case and how things went with Apple. And it's very instructive where that's what the fight is. And if you're willing to keep fighting, keep showing that you have a strong trademark, you've advertised it like crazy, you can show that you have been on the offense with this trademark. It will strengthen your defense. That's how it works with Apple. And unfortunately, it's just the way it is. The bigger you are, the louder your trademark can be, the stronger it is. So that's our lesson for today from the Apple case on Live Photo. Thanks for joining me. I'm Wayne Carroll, and this is Leveraging Inspiration.